Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Mr. Smith, can you hear me?
Yes.
Okay. This is State of Michigan versus Levanta Smith, case 24057499901. Today is the date set for the redetermination hearing. Appearances, please.
Emily Reagan for the people, Your Honor.
Philip Reagan on behalf of Mr. Smith, judge who's here present for redetermination hearing.
Mr. Smith, did you retain an attorney in this matter?
Not that I know of.
Okay. All right, Mr. Reagan, this matter was set over from yesterday. He had a court appearance yesterday before Judge Edwards in circuit court. It's my understanding there was a remand in that case. And I'm sorry, Mr. Smith, I just muted your device. There's a lot of background noise. But if you need to talk with Mr. Reagan, just raise your hand. At some point, I'm going to let you be in the breakout room with him. And I see you nodding yes, so you understand what I'm saying. Mr. Reagan, anything as to bond?
Judge, I just want to say, Judge, no, I want to say that Mr. Smith, Your Honor, is 37. Obviously, you just told me some information about Judge Edwards and the remand. This is a very serious case, Judge. A lot of counts here. He lives with his fiance, 2 kids in the city. He has some non-assaultive stuff that's, I think, pending. He had a remand for a CCW case by Judge Edwards. I just want you to understand, Judge, that Mr. Smith was actually shot by the complaint. Now that's something that has to be brought out through testimony. Mr. Smith's gonna get a chance to tell his side, tell how he was shot. He had to go to the hospital, but obviously there's a lot to this, Judge. There's a lot to it, but we're early. It's an early stage, Judge. So I'm asking the court for some type of nominal bond. He has a remand on the CCW. Now I'm not sure how long that'll last, but something nominal, GPS tether, house arrest. My client was arrested at the hospital, Judge. You know what I'm saying? Like I said, my client was shot. So it's a lot going on here, Judge. A lot to figure out. Prosecutor has it, I believe, wrong. In this particular situation, they have some things wrong, I should say. But I want to ask the court respectfully to reduce the bond from $250,000 cash, which is totally unaffordable, Judge.
All right, Mr. Ragnan.
Well, Your Honor, as Mr. Reagan said, a very, very serious matter. We think the $250,000 cash bond is appropriate in this matter. The defendant, police were called to the hospital where the defendant was because he had been shot. When they asked the defendant what happened, he gave them some other location which was not the truth. In checking his name in a lien, they found out that there was a warrant for his arrest for violation of probation. And with that, we're able to determine that he lived on Auburn Street. So they checked the shot spotter system and they found that 21 shots had gone off on Auburn Street and 4 additional shots, which are probable shots as well. So that's where the incident occurred. They sent people to that location. They found multiple handgun spent casings at 924 Auburn. They spent shotgun shells were located there as well as suspected bullet holes in the home and in a Buick LaCrosse. What happened is the defendant and victim number one, Mr. Leonard, had walked to the liquor store, and on their way back, they ran into and talked to Jermaine St. John, a co-defendant, also known as Maine. Okay. And when they talked to him, the victim, number one, Mr. Leonard, didn't get along with Mr. St. John. And so the victim said to him to fuck you. With that, he walked away. Now, Mr. St. John went in the house and got a gun. The defendant went in his house and got a gun. They both said to him, first, Mr. St. John, we're going to blow your ass up. Then the defendant says, we're going to blow your ass up as well. And so as he's walking towards his house, he looks back and sees both of them walking down the street towards him, holding guns. Now he goes in the house and gets a shotgun to protect himself and Miss Robinson, who lives in the residence as well, and goes on the porch and said, I didn't do anything to you. With that, this defendant starts shooting the first two times, Your Honor, at the complainant. The complainant starts shooting back. Subsequently, this defendant is wounded. When they left, the complainant went in the house and waited for the police and said, I loaded my gun to protect myself and the complainant. Now, the witness here, victim number two, Ms. Robinson, said she looked out the window and saw Tay, which is Levante Smith, this defendant, and Maine, which is Mr. St. John, outside with guns. She hid in the closet. So, Your Honor, there is considerable evidence in this matter. This is what happened. The defendant admitted that I may have been there, but I was drunk. Okay, so he's admitted that he was there. There is a probation officer said that there was a warrant for his arrest for violation of probation, and he was ID'd by Mr. Leonard and Miss Robinson as well, Your Honor. So we're asking for the bond to remain in place. Thank you.
All right. These are allegations. And I would note Mr. Smith was arrested at the hospital with a gunshot wound. I don't know the full extent of what happened here. I won't even start, to believe that I have a handle of what's going on. This is a highly dangerous situation that at least 3 or 4 people are shooting weapons. This is on a Detroit City block. And Mr. Smith, you're going to get your day in court, whether you're, innocent or guilty of this charge. You're going to have a day to make those allegations that people are going to have to prove beyond a reasonable doubt that you did what they said that you did. The bond is going to remain in place on this matter, as I do believe that this is a highly dangerous situation. There's supposed to be no weapons. That's a condition of your probation. And I would note that there was a violation out before this hearing. I don't believe that I can keep the community safe without a high cash bond in this matter. So bond is going to remain the same. Sir, your next date is June 13th before Judge Sabri as to this matter.
Thank you, Your Honor.
All right, that concludes the hearing. If you guys have Mr. Rambus, we're ready for Mr. Rambus now. Mr. Bassan is here. Mr. Rambus, can you hear me?
Yes, sir. Yes, Your Honor.
All right, Mr. Bassan, you ready?
I'm ready, Judge.
All right, this is State of Michigan versus Andre Rambus, case 24057-48201. Today was the date set for the redetermination hearing. Bond is intentionally unaffordable. Can I have appearances, please?
Samuel A. Ragnan, Your Honor, for the people.
And again, Your Honor, Attorney Kevin Bassan, P71061, on behalf of Mr. Andre Rambus, who's present by Zoom video from Wayne County Jail.
All right, and Mr. Rambus, could you state your name for the record, please?
Andre Tyrone Rambus.
All right, thank you, Mr. Rambus. Bond is set intentionally unaffordable. Mr. Basant, what do you have as the bond?
Just so the current bond is 100,000 cash surety, Your Honor, which I believe is still technically unreasonable and unaffordable for Mr. Rambus. What I'm asking for, Judge, is the court would consider 100,000 10% bond. There's already a tether condition. Judge, I understand that these are very serious charges, and Mr. Rambus understands that as well. But Judge, he would have absolutely no contact with the complaining witness whatsoever. He voluntarily surrendered, voluntarily turned himself in. We have been working with the detective on this particular case, so he's not a flight risk. In terms of being a danger to the community, as the court knows, these are allegations, Your Honor. He has had, to my understanding, no felonious contact with the law since 2017. We plan to address these particular charges. I know originally the prosecutor recommended a $500,000 bond at the arraignment, and thankfully we got $100,000 cash. But Judge, that's still unreasonable. He's unable to post it. 100,000, 10%, I think is still a significant bond. He's gonna be on tether. He's gonna be under supervision, and he's not going anywhere. He works. He's gainfully employed. He needs to get back to work, and would have no contact with any other witnesses or complainants. So, Judge, I'm asking for just a 10% condition.
All right, Mr. Ragnan.
Your Honor, this is an incredibly assaultive matter when a person deliberately, premeditated, walks upstairs and shoots a man who's in bed with his former girlfriend. He knew that, in fact, his former girlfriend was dating this man, okay? So he comes through the front door, walks upstairs, points a gun at him, and shoots the victim, who's shot in the leg, Your Honor. Luckily, he's a bad shot. Then he leaves and goes down the stairs. And what happens when he goes down the stairs, Your Honor? He can't find his car. So he leaves the residence, and he leaves his Chevy Avalanche vehicle parked in the driveway and walks away. However, he comes back a few minutes later and then climbs through a window, okay, a bedroom window, to get into the residence. He can't get in now, okay? It looks for his keys. Now, what happens, though, is that you have two witnesses in the house, all right? You have one witness who, in fact, said that he was on the first floor of the home when he was awakened by a gunshot. After the gunshot, he observed the defendant come down the stairs from the second floor and began looking for his car keys. He said he couldn't find them, and then he leaves. Then you have another witness who sees him come in summoned through a door in the back of the house. I made that mistake earlier. Back of the house. She looked and saw the defendant, Andre Rambus, run upstairs. She hears a gunshot. Then Rambus exits the front door of the home. He goes out the front door. Then she sees him return, climbing through the living room window. My mistake, Your Honor. They find the gun. They find a spent shell in the bedroom. There's 4 people who can identify this man. He shoots someone. I think the bond should be $500,000. I certainly think it should be more, but I definitely don't believe that tether would protect the community, that tether would protect anyone, that he deliberately tries to kill someone, and I'm asking for the bond to remain in place. Thank you.
1 second. Okay, I will start with the understanding. It looks like Mr. Rambus was discharged from parole about a year ago for the CSE third offense, where he was he had a prison sentence. Okay, I'm just making sure that I'm on the same page. It looks like there was some earlier assaultive history, but there aren't any convictions outside of the main assault at CSC. However, the fact This is a highly, highly dangerous situation. It sounds like not only these are allegations that a person was shot, but it's shot in a bedroom while they're laying down, which is a highly vulnerable place. And then there are multiple witnesses on this case. Quite frankly, I think 100,000 cash surety is more than fair of a bond. I think this is a highly dangerous situation. I don't trust Mr. Ram. As a matter of fact, I take that back. I'm going to set this as 500,000. 500,000 cash surety. I don't believe this person should be out right now. I think this is essentially a remand, and that's the intention. If this person is shooting somebody in the bed with multiple people in the house, this is insane.
Judge, respectfully, I know the court has ruled, but
no, Mr. Basant, I understand. I'm gonna let you make your argument because I did something that I normally don't do. But these allegations, as presented in a case history, leads me to believe something else. So, I'm gonna let you make, any argument that you need to make right now, and I'll listen to you.
Well, Judge, I don't want to go into details of the defense, Judge, but there are elements of self-defense. What the people are going off of is what was told to them by the witnesses, right? And so he has one side of the story. He doesn't have the whole side of the story. And so my argument for bond, Judge, is that this man has not had any contact with the law since 2017, but for these allegations. The $100,000 cash bond was, in my opinion, unreasonable, and I seriously doubt if he's going to post it. And so, Judge, I'm asking if we could at least keep it at 100,000 cash surety with tether, because there was a tether requirement. That's still an extremely high bond, Judge, even at 100,000, and allow this to play out in court. And so, Judge, we worked with the detective on this case. We've never been on the run. We've never tried to hide or evade it. And so that's why we're here, Judge. So I would just ask at the very least if we could keep it at 100,000 cash surety with tether. And he self-surrendered, Your Honor.
Your Honor, they found a spent shell from his gun in the bedroom. So self-defense, I'm not sure about that, but I don't need to say any more. It's just a terrible thing. I think it's premeditated. Maybe I think the $500,000 is appropriate, Your Honor. Thank you.
Mr. Basant, you indicated earlier that the defendant has been working with the detective for self-surrender. You did say that earlier, and I did not take that into account into my consideration as far as raising the bond. So I will keep the bond where it's at, the $100,000 cash. I don't know if he's going to post it or not. It's not 500,000. I still stand by my analysis as far as the dangerous allegations that this situation created. You've also indicated that the defendant hasn't had criminal contact for, since 2017. But I would note that, half of that time he was detained. So, that doesn't hold as much argument as it, as the 7 years in total. But I will keep the bond where it was at, the $100,000 cash with the tether, and I won't raise it.
Thank you, Judge.
Could I just ask you to consider no surety, leave it at cash? I mean, this very.
No, I'll leave the bond. I'll leave the bond where it's at.
All right.
Thank you, Judge.
All right. Bond is continued.